We were eagerly waiting, that you would make available that you had promised that you would make it available.
Yes, we have, after meeting, we have prepared a short
Yesterday it was
chart.
completely ready. Oh, this should have been secured yesterday, is it?
Yeah, we were querying, asking from the office.
Okay, no, sorry, but I was not here. I was in the family.
Yeah.
But anyway, I had the chance to speak to other doctors. They sat over the weekend. They had multiple meetings, a couple of meetings, and they have.
Let's see what.
That's the flow chart which you have.
But before the flow chart, this is the summary of what we discussed. Now the flow chart is varying with this summary only in one part. I will just come to that. I'll give the chart which we had discussed, and it's the same thing, only two small variations. I'll come to that later.
Hmm. Yeah.
This is the one we broadly agreed. I think only one reservation they have is that once the primary board doesn't agree, they want that to be again referred to the review board, which we are not acceptable. This is not a situation under which this is not an appeal or anything. That's the one.
So you now just tell us what.
The only thing is, what I was, when I spoke to doctors again at Bombay, and also here, this time allotted, they're saying primary board within 24 hours and review board within 48 hours. Because what they're saying is every day in the ventilator is an agony for the patient, and the primary board doesn't require 48 hours to come to a decision that it's terminally ill, etc. So one request is on the left-hand column, Lordship makes it 48 for 24 hours. And they say review board, in fact, they are saying review board, many people feel there's no need for a review board, but since they're having a review board, let it be there in original judgment. I would say 24 hours, 24 hours. That's one point. And secondly, Mirot, this secondary board, sorry. Lordship has got secondary board in the middle, Mirot.
Correct.
This one or this one?
No, this one. Because here, everything except there are 2 points of differences. One is this 48 hours, 48 hours. They are requesting it 24, 24 because time is of the essence. And secondary board, doctor nominated by CMO. Our suggestion is not what we had suggested, and in fact, the discussions took place, they initially agreed. Instead of having every time a person nominating, let there be a review board wherever available, where this review board is always there. And that they can take a quick decision because the primary board has taken it, they've got a report, they give reasons that he's got this 4th stage cancer or 4th stage this point. The time is very limited. So the review board, because again, if you nominate the review board, that doctor must be free, he must come, all those problems will arise. So
No, this when you talk about
secondary board. Yes,
you said 2 subject experts not part of the primary board.
that's agree. That's fine.
Now these.
The only difficulty is doctor nominated by CMO. So Lordship can think of some modification.
So nominated by, no. You have said doctor nominated by the CMO plus 2 subject experts. Are the subject experts also to be nominated by the CMO?
No.
This is what we want to know.
No.
Second thing is whether the 2 subject experts must be from a different hospital.
No, not necessary.
I mean,
We did discuss that threadbare, not necessary.
when you say not necessary, we are only putting to you that there may be cases where you may not get, the first board will have a subject expert. Then if you will need to have another 2 subject experts.
Yes, if they're not available, they'll go to the nearby hospital.
That's what you.
Wherever available. No, suppose it's like Safdarjung Hospital or say in Madras Government General Hospital, which has got a 10-story building with 200 doctors, then there's no problem. In fact, I was suggesting to them that because it's a trial basis, because like any product you have a marketing, trial marketing, whether to start it in major hospitals, but they didn't want to complicate it. So I'm also not getting into it. So one is 24 hours, 24 hours. Now, your Lordship may suggest what instead of nominated by CM, if your Lordship has got some suggestion to make it workable.
48 hours mean it starts ticking from when?
So from the time the patient is admitted, and or suppose he's there for 8 days, 8 days he goes into a coma.
Once constituted.
If you tell us,
Once
this
constituted.
48 hours will start from when? Does it start, clock start ticking?
Constituted. Once constituted, they have to, once it is constituted.
my doctor colleague here says that 24 hours from the time they know that the end is inevitable.
It is 48 hours, isn't it?
No, we want to suggest 24 hours because uniformly they have made it 24. The government is suggesting 48. We are saying at least primary board because they are the treating doctors. They don't require 48 hours to make up their mind. If you see
It's
treating
not so
him,
difficult, no? Doctor will say that end is inevitable at this point of time.
yes,
I mean, 48 hours is, I think, very reasonable. So that is not,
or Lordship can say not more than 48 hours,
they can do it at the earliest,
but not more than
but
48
not
hours.
more than 48 hours.
Yes, that's okay.
And that too, this cannot be, supposing you do something beyond that, then will a contempt lie? We have to be careful.
No,
Somebody will come and say that 48 hours is
we'll,
casting
we'll
stone.
see you in charity, but it has
No,
taken
don't
hours
say
to.
that we will see it. We have to, Datar, you have to be careful. The direction of the Supreme Court, it will be binding.
Yes, Lordship may say not more than 48 hours, within 48 hours. Within 48 hours.
So what is the new?
Within 48 hours is enough.
Whether it's
Within 40.
primary board,
Body board.
No, 48 hours to give the opinion. The primary board is the
No,
treating physician.
how does one file a petition or how would that happen?
Bro, there are two cases. There
They
is
have
an
to
advance.
obtain the opinion of the primary board.
Yes.
No,
Because they are reviewing on that.
initially the attending doctor to advise that
No, there are two cases. Cases where advance directive exists, cases where advance directive doesn't exist. That is para 198 of the judgment and para 199. So
but
199
even
if
if-
advance directive doesn't exist.
even if
No.
advance directive exists,
Let's go to that category first.
uh,
So just for easiest.
then also it's difficult. Somebody must say that it's a point of no return.
Yes, that's a treating physician.
That has to be treating
The
physician.
treating physician.
Then he will refer it to the primary board.
But he is not, his opinion doesn't count. He has to bring in two
No,
more experts who
He has to
concur with him.
refer it to the primary board.
He is part of the primary board.
Okay, so he
Part of the primary board. So it's treating physician plus two more. So within 48 hours, we say 24 hours, Lordship is saying within 48 hours can be even, because suppose a
this is applicable only in the case where there is an advance directive.
No, that is, I'm just saying two compartments. One is advance directive where the person's wishes should be respected.
Correct,
And what the Supreme Court says is that should be respected.
correct,
And the primary board decision is only subject to a review board.
correct.
Now, suppose there is no advance directive.
Then we are not here to.
No, that's para 199. That's a very important part of the judgment.
Let's therefore see which are these provisions, how do you superimpose them?
Yes, here.
Which one?
I'm just saying, no,
Here we don't have it.
no, I just go step by step.
That's right.
If the advance directive is there, in the format suggested by the Supreme Court, which
This is
is
a joint
made,
submission.
signed by two witnesses, etc. Lord, can I do one thing, Lord? Better is this is the agreed, like a minute which we discussed and agreed upon.
This one.
No, this narrative.
we'll have to place it along with the directives already exist.
Lord, what happens is,
See
Lord,
which
this
part
directive
is
and this chart matches except this 48 hours and secondary board. Everything matches. This is a very simple format. Instead of reading 8 pages, this is,
And also doing away with the judicial magistrate or whatever.
that's completely done away. The judicial, then we might as well close the case. It's not possible. Then there's no point in having advance. Only intimation to the judges. The entire para 199 of the judgment. at
No,
page-
but Natarajan, this judgment was only dealing with cases where there is a
Advance directive.
advance directive.
Advance
Para
directive.
199.
I think Mr. Datar
Yes.
does take into account a situation where there is no advance directive.
Yes.
And paragraph
99
199 deals with that.
No, it's only with that. Then
Right.
you have to, then you require the consent of the kith and kin. Then the doctor can counsel them.
No advance.
Just read para 199 so that
Yes, yes.
there is a clarity.
At page
Even after
133.
that, you are also.
Yes, yes. In case there is no advance directive, that's what it says, second sentence.
Advance
Para 199.
Right.
Where there is no advance directive, the procedure and safeguards are to be same as a case for advance directive.
Terminal and undergoing non. So it's 199.12.
Yes.
It's the same, huh?
Yes. Broadly the same.
Is there any difference?
No, no. Only the consent of family is required. The very idea around the rate, you don't need the consent of family. The patient wishes is respected.
This is the family.
That is with
Advance
advance.
directive, yes.
Without that, it's going on now also, with consent of the family.
No, now what happens is when this Supreme Court judgment comes, then there is no allegation, the doctors are protected. They consent. Now, without advance directive, they get the consent of the family. The family can choose, no, I want the person to continue indefinitely.
What
They're willing to pay for it, yes.
What will happen if a family consists of the wife and say 2 children?
Hmm.
And what is the definition of family? Would you take in brothers?
Immediate family, we're saying, immediate family.
What do you mean by immediate family?
Available.
We are telling you what you'll run into problems. We are telling
No,
you.
not what.
Supposing you have, let's say, the wife says,
But Lordship, imagine a practical situation where X is, suppose a senior lawyer finally goes to the hospital. Who will be the family, his son, wife, etc. Now we can't say his brother also is there.
supposing we are asking you,
Yes.
supposing say the 2:1. Supposing a close family, say wife and 2 children, let's take it.
Yeah, well, I discussed that. Then what they say is, then the people will say that the person, the family which wants to continue will bear the cost of the treatment. They will bear the cost. Because when the doctor has said that there is no point continuing the treatment, they define what is family.
Okay.
In page 7, I just read it.
Anyway, we will not get into that.
No, spouse or de facto spouse or partner with whom the patient has a relationship as a marriage or a friend.
Why should we incur a honestness and create more problems? We thought that it should be Nataraj's lookout to tell us, but
No, but AIMS has got it, Lord. Spouse, adults, sons, where available. Then if adult sons, children not available.
okay, now we have got it. So both advance directive and no advance, both
Yes.
it is applicable. Now let us see which are the provisions which are to be modified.
Yes. Now, if your lordship wants to
So
speak.
this is a clarification petition. We have to bear in mind. We can't take it
Correct.
unless there is complete consent.
Yes.
Yeah,
No,
no,
but I'll do one thing. This is the chart they gave me finally.
That's right.
This also matches. They tell me this matches. Only where there is the point of difference is it
So what
48 hours or 24 hours?
We intend to dictate the order right now.
Yes.
To what?
Yes.
So that it can be done any correction.
Yes.
modification can be done.
Yes. Now, but only thing your lordship has to say.
So what we intend to say, the format is, we'll tell you what you're going. Just say what the clarification, and then the preliminary
Yes.
hearing.
But your lordship.
So today you have come to us, and we'll set out the procedure which has been laid down in this clause, so that anybody who reads the order, we will know.
But we have suggested in the narrative form. Lordship may follow this if your lordship so pleases. This chart, which is called, it's got into 7 pages.
No, what we have to do. See, there is already directions. So one set of directions.
Exactly.
So to what extent those directions, which are those directions which will stand
That is
modified?
also done. 3 things are done. This is the modified directives. This is the chart for your lordship's easy reference. And this is the final chart which they gave me just now before lunch.
So let us see that, modified chart.
Yes.
Because
What they did.
if we give the original chart, original directions, and then we say that it is clarified that, then that will do the
It'll be
trick.
easier. It'll substitute
It will
that.
be both, so
Your
that
lordship is
somebody
right.
who reads it will know what to say.
I appreciate. Lordship is right.
This is what the format we intend to do.
Yeah. This is the latest chart with black and red ink.
Where is it? This one.
Yes. Lord, is it the page 1 ends with 198.3.5? The first page, is it? end?
That's right,
That's the chart.
3.1. With a red date.
Yes.
That is, and attested before a notary or,
Your lordship suggested and because your lordship said put or gazetted officer.
This one, page 7 and para 7. Page 7, para 7 of this note.
No, don't come to that. Don't see that right.
This need not read.
Not only now, today, black and red.
so, you have said in 198.3.2, that the witnesses and the notary shall record their satisfaction.
Yes.
Now, in the earlier clause, you have permitted and attested before a notary or gazetted officer.
All right. Lordship is right, because then it will be in synchronization with one.
Yes, because supposing it's before a gazetted officer, he should also certify
Right.
witnesses and the notary or gazetted officer, correct?
Yes.
Shall record the satisfaction that the document has been executed voluntarily and without any coercion or inducement and with full understanding of all the relevant information. Then what is to be done with this, what do you call this, advance directive? What we had in mind, we had a discussion. One more additional safeguard we wanted to incorporate, which is that once this is done, they should get back to him that he confirms in writing. It is just an additional safeguard. See that you have done this, and he writes back. So that will be kept along with the original declaration. This is to avoid any kind of fraud which you can, and it's somebody who is doing it in writing.
Give it to your Lordship, because suppose I go to the gazetted officer, I sign it before him. Now,
Or he comes before you.
whatever it is, it's very unlikely. He may want me to come before him or for a notary. Notary, I'll have to go to the court campus and get the notary to do it. Now, I sign it before him. Signed before the notary, public witnesses are there. Now, in my humble submission, it may not be necessary for them to ask me, are you really written? And I write back to him. I'm signing it before them.
We know that, but we are just saying in our country.
You can put it before Lordship. Because what I spoke to some doctors again in Pune and Bombay. They said that
What
all over the world.
Some safeguards, whatever this one.
That'll. Then where is
No, because in a will, we don't say, did you sign the will? Yes, I signed the will. I signed it.
No. What is
that
done with this? What is to be done with this?
Which one? No, that goes to the National Record Mission. That's coming later. The National Digital Health. Yeah.
Probably independent countersigned.
Lord, I'm told that later in the day, this document is handed to the family members. One copy to the Gazette officer, and one electronic record is kept with the national
Part of the digital health record.
part of the digital health record. So even if I have an accident somewhere in Bangalore, it can be accessed anywhere.
So these notaries are governed by the Notaries Act.
Yes.
Is this a document which is actually contemplated under the Notaries Act? Because
Yes.
they got a stamp, etc.
No, there's a notary stamp. He puts
That's
a,
right.
it's a
So
stamp.
is this a
It's
document?
actually rubber stamp. He doesn't put any court fees. He just puts a rubber stamp.
That's right. That's right.
He's authorized. He's been authorized by the respective high court to be a notary public.
That's right.
Authorized to administer.
So do you want to? Be done this.
In page 2, the Lordship's answer is in page 2.
So we are deleting, we have to also now see that JFCME goes out,
Yes.
shall forward one copy to the district.
JFMC goes.
That is also going to be deleted?
Yes,
Nataraj, you're agreeing
Yes,
with that?
yes.
Rest of it. All right. Then 193.5 shall inform the immediate family members of the executor, if not so. Executor shall inform and over a copy of the advance directive to the person or person named in paragraph 192.5.
This was your Lordship's suggestion.
Hand over a copy of advance directive. Within what time? Supposing he gives it after the, fix the time.
Let it be, Lord. You can't, we go, expeditiously.
Put it within a month. So that, it will become certain.
Because I spoke to some doctors who are dealing with some similar cases. They said throughout I'm not talking Western world, they said they take it like a will. It's just a declaration that it happened, that's all. There's no great formality. I must put into some US medical record and all that. The document is just available, that's all.
98.2.5 is who? 198.2.5 is who?
It's in the 198.2.5
Ah,
is in, one second, is immediate family, one second.
should specify the guardian or the close.
Specify the guardian or close relative who in the event in becoming capable.
So it'll go to him.
And Lordship said put guardians, Lordship said put in bracket S. Guardians,
That's right.
guardians or close relatives.
That you have not put in this note.
No, only what is to be modified. Lordship wanted only the things which are modified.
That's right, but it should be there, no?
The 190 is not being changed at all.
180.2.5, we have suggested
Yes,
in place of guardian or or
Okay,
relative, it should be S.
yes.
Because in case that man dies,
Yes.
or he becomes incapable.
Then 198.2.5 should become plural.
That's what we are saying.
Your Lordship is right.
198.2.5, we are writing it here, eh?
Yes.
It's your 0.2.5 will become parent, guardian will become
Guardians or close relatives.
or it will become relatives. That's right. So that is okay. Then 198.3.6.
Yeah. Your Lordship asked who? He also choose because of privacy issues. Lordship said that leave it to his discretion.
No, this 198.3.6 original will remain. You want this red portion to be added.
Yeah, the original portion will be there.
Will be there.
Yes.
Ah.
So only the red part will be added and aforesaid will come. Oh, aforesaid also this. Aforesaid also is there.
Do you want to put any time limit within which they should do it? Not necessary. Okay. So a copy shall be handed over to the ground. No, you are adding what actually? This red portion is to be added, that's all. No? We're going
That's all.
complicated.
That's
But
all.
you have said something shall be handed over to the after that.
That's the same paragraph.
Repetition of.
There is a repetition. Na? What we thought was
Yes.
this red portion can come at the bottom of the original clause.
Correct. All right.
Then we don't have to add that. You follow. So we are just cutting that portion.
And
The
shifting
right
it to
hand-
the bottom.
Huh?
And shifting it to the end.
That will come to the bottom of on the left hand side.
Yeah, I agree. No.
That then JFCM that is deleted. That's right, no
Yes.
problem.
Yes,
In the event, then comes 198.4.1 becomes terminally ill. In the event or is in the end stage of a chronic disease
But it's come from the ministry, my lord.
and is undergoing prolonged medical treatment with no hope of recovery and does not have any decision making capacity. Four point one. Have a day's reflection and dictate it tomorrow. I mean, that you dictate it tomorrow.
Yes, please. And I would request if your lordship still feels something else, we have to mull over. So also because it will be now, what your lordship pass will be now permanent.
You see,
Till they pass the legislation.
One should go through it.
But can your lordship go through it just now quickly?
That's right. So that, whatever.
As if your lordship has got any particular doubt, then.
That's right.
No. Because I'm not having doubt, I'm technically.
So now this, what do you say, 198.4.1, this is a radical change.
Sorry.
The radical change is or in the end stage,
No, that is the request of the ministry.
whether it's the ministry or whether it's you.
No, that's also this
Completely-
Chandrachud's judgment.
We are tinkering with the judgment.
No, Chandrachud's concurring judgment also says that. That's also Article 141.
No, that's not. So this is completely changing
Or
the,
delete it, my lord. Delete it. Anyway, it's terminally ill.
in the event, yeah, that's what we thought. And is a prolonged
I have
underlying.
no problem, my lord. It is a ministry suggestion, what you want, because terminally ill is terminally ill. But terminally ill is wide enough to include this. Technically speaking, it's a genus.
It's a jail.
Terminal can be all the species of that.
Absolutely. Terminal ill person
See, once
would also be the end stage of chronic illness.
Give it.
Why do you want to, Nataraj? Why are you insisting on that?
No, they thought should be some kind of check on the authenticity
Why
and
we are saying
situation
the
also.
original.
But they were doctors also.
It's a clarification.
Yeah.
And we should not be, doing it on what those judges taught and, conducted.
Very well.
Because if the first part takes care of it, because it says in the event of the becoming terminally ill
I think we'll read it.
and is undergoing prolonged medical.
No,
everything
Lordship
there.
straight away cut it out. Lord.
Yeah. We are not England.
2.2 also.
There's a saying, Mr. Datar,
Yes.
when thinking men think there's nothing to think, it becomes time to think.
Very true. Very profound also.
And then you have added another red there and does not have decision-making capacity.
This is very necessary, my lord. This is very necessary because I may have an advanced directive. If I have a decision-making capacity, I can change my mind also. So let that be there.
For a change, you are turning pro-life.
For a change. No, Lord, I am not pro-death, my lord.
And cure of the ailment, then you have brought in treatment when made aware of the ascertained the genuineness and authenticity of evidence to the existing digital records of being or from the custodian of the document mentioned in, that's okay. That addition is, I think, welcome. So we'll get this information from either this or that. That's okay. That does not have decision-making capacity, what you said is, I have no problem with it.
But they're very serious about it. They want it.
So he may say, I don't want it. He say, don't do it, something like that. Or he is saying, do it fast. You don't know. All right. So that is, I think, subject to what you may think about it. We can. Then comes 198.4.2 instruction. The document must be given due weight by the doctors.
Again, that has to go, my lord. 198.4.2. Again, that chronic illness can be cut off.
Or in the end stages.
That's been cut off.
Not at all necessary.
Not-
Then comes
198.4.
0.3.
That's very minor. Also,
If the decision treating with is satisfied, the instruction given in the document need to be acted upon. You shall inform the person's name. Yes,
that's it's automatic, my lord, nothing to.
that's nothing much in it.
No, your lordship has to really decide on 198.4. There we require your lordship's inputs. The bench has to decide on that.
So the person so and so has replied if the steps were changed. Then 198.4.4.
Yes, that's what I'm saying. There your lordship has to take it.
To where the executor has been admitted to medical treatment shall then constitute a primary medical board. I just want to highlight one, supposing somebody was executed an advanced directive, gets admitted in a hospital with just the rudimentary medical facilities. What will happen then?
Nothing. There will be no primary board.
There will be no primary board. Then what will happen then?
Nothing. He continue treatment or he will die, whatever happens. Nothing can be done. Lordship is right. Suppose a person gets an accident in the highway somewhere, he is taken to the nearest health center. What to do?
What to do? Nothing can be done. Okay. Admitted for medical treatment shall constitute a primary medical board consisting of the treating physician and at least two experts with. Now, this is a major thing. You're going to cut down, take out the 20 years experience safeguard, substitute it with subject expert.
Or at least 5. Because the answer was the person gets subject expert when he's 33, 34. He has to study, keep on studying till 24, 25, 26. After MBBS, then they do residency, then they do MD, then MS and so on and so forth.
And you're making it 5 years.
5 years experience.
What is the view of the government here?
They had agreed to this. These are all agreed suggestions, my lord.
That's right. We wanted to confirm to that. Nataraj,
Please.
now here we want to know how will this 198.4.4
Yes.
it involves actually, at head of the treating department and at least 3 experts from the fields of general medicine, cardiology, neurology, all of that goes?
No, we said about the 2 subject experts, that is with 5 years, that is sufficient to this.
Because Lordship said last time, subject experts will be better than instead of putting multiple departments.
What I thought of doing was that to add to that. You see,
So I would suggest, let's just put
because
subject experts.
why the earlier bench thought it fit to call out these disciplines separately expressly.
But suppose a person is, let's say, having terminal cancer. So I think the experts will be oncologists. He's not going to call, say, somebody from hepatology or something like that. We just put subject experts. So Lordship also suggested, so putting all, suppose hospital doesn't have one doc of that particular branch. And now they say, all these, is it one from each? Is it 2 out of 3? So all those problems come.
So the subject expert will be determined by whom?
But the primary board,
No. Subject
hospital.
Hospital.
Yes.
Who in the hospital? Hospital means what? Somebody
director
must
of-
take that call.
The administrator, the director, the medical leader. So suppose it's a large hospital, say controlled by a large family. Suppose a family is running a hospital with 50, 60 beds. Father is there, wife is a doctor, children are. They will then, patient is treated by some doctor. That lead of the hospital will take a place.
This is the only area where, I have.
For a hospital is to form a primary board because treating physician plus 2 more doctors, that's all.
Actually, subject expert relates to the patient,
Yes,
the ailment that is suffering.
Ailment.
So it is nothing to do actually with the decision of the, director. etc.
Because the director may not be in that field also.
So it will actually relate to the ailment of the patient.
Absolutely.
And my lord, Justice Joseph asked, suppose it's a medium-sized hospital, they don't have 2 subjects. They'll have to get the neighboring or nearby hospital just to come and confirm.
May take up what makes his opinion. This is a preliminary opinion. Who in turn shall receive both the just to provide for that. Supposing somebody wants to knock out this man's will. And the time was really not ripe in terms of the advance directive and the ground
My lord,
reality.
only one thing is the man is.
What would happen is that
No.
you bring anesthesiast. He's a subject expert.
My lord, we are dealing with a case, person is terminally ill. If not today, he's going to die after 1 week. So there's no question. And I asked one doctor, he said, look, elementary, suppose
I bring a pediatrician.
No, I won't take him to the hospital. I will let him die at home only. Why should I take him to the hospital?
Subject
If a person is terminally, but if a person is terminally ill, he's dying, he's in a coma, he's gone into, he's got suffered a major stroke. So one question asked was,
Can we add subject expert having regard to the nature of the illness?
Yes.
so when you say subject expert, that's what it means.
Yeah, just, to
Perfectly, it should be subject expert means it's relatable to the ailment of this one.
ailment of that
No,
person.
I was, like your lordship said, terminally ill includes chronic illness. My humble submission is subject experts will include that, it's a given.
Let us not, leave it to chair. Let's
Yeah.
say that having regard to the illness. What do you say, doctor?
Yeah.
You have any suggestion there? Because
Sure,
if you say subject experts having regard to the illness,
we can write with the concerned specialty.
Subject experts of the concerned specialist.
Specialty is a generic expression. It will include any specialty which is relevant at that particular moment.
that's why you said relevant to the illness.
He's saying put concerned specialty.
The specialty concerned. Concerned means concerned with the illness. This is how they are worded in other jurisdiction, specialty concerned.
Subject experts of the concerned specialty.
Specialty.
That, at least that should be there.
Okay.
It will make it somewhat specific.
Otherwise, they'll call some other specializing. Of at least 2 subjects expert of the concerned
No,
specialty.
not should be added at the end of 5 years. Of at least 5 years experience in the concerned specialty.
Okay.
That may be better.
Now, what do you say about this 5 years?
No, that 5 years I don't agree.
Huh?
5 years, no limit of experience should be added. then it will be very difficult, it will not be practicable.
But 5 years is
At least
You already are in neurology.
5 years.
Neurology, he passed MBBS, then he did MD in general medicine, then he does MD in neurology.
He doesn't do MD.
More than 10 years he has been in this profession already. A super specialist has put in 10 years of his life in studying that specialty.
Five years remain doctor, so that expert of at least. Now, when you say two subject experts of at least,
5 years experience in
of
specialty.
experts with at least, it should be.
No, yeah,
Of
experts of at least 5 years experience.
With
at least, let's put with, at least 5 years
expert
experience.
With at least,
5 years experience in the concerned specialty.
in the concerned specialty. So it means that, we should be clear in our mind, because that is after MBBS, he does say, for example, MD medicine. Correct. The super specialty is DM medicine. Okay.
Another 3 years minimum.
That will be another 3 years. So when you are talking about the subject expert, are we talking about somebody who is that is DM or MD?
We just put 5 years, bro. Just put 5 years in it.
So
We want to at least know what we are doing.
No. Why I'm saying concerned
So we
specialty.
are cutting down 20 years.
No, the
That's
point-
why we are asking you, we should be clear in our mind.
No, I put it this way.
You take another case, you take cardiology. The same way. You've got DM cardiology.
Yes.
I think you have got DM cardiology.
yes.
So what is,
I put it
is
this way.
the
Suppose the
subject?
person has worked in the cardiology department. He has finished his MD general medicine. He has been put in the cardiology department. Then he doesn't get admission for
No,
1 or 2 years. Then he joins after 2 years.
He would have done MD cardiology.
Yes.
You see, you can specialize in cardiology right after MBBS.
Yes.
Correct?
Yes.
You don't have to do MD, medicine.
No, we cannot do directly. After MBBS, we have to do MD in general medicine. Then we can enter the specialty cardiology or neurology or oncology, whatever it is.
Do you have to do MD medicine? I mean, to become a MD cardiologist?
It's a 5 years
post-graduation. After post-graduation.
Only after post-graduation we can enter the specialty.
After MD medicine, then only you can go further for MCH cardiology.
Yes.
What doctor is saying is 5 years experience after post-graduation.
That is what I'm saying.
After completion of
The
post-graduation.
super specialist has already been for about 10 years in the field. That is 8 years after, 6 years after passing MBBS.
When I spoke to doctors, they are saying, please, they are saying that, look, a man is terminally ill. It doesn't require a man of 20 years to know that he's terminally ill. We are dealing with cases.
Even Datar can say that.
No, I can't say. No, but I'm saying it
One
doesn't
look
require
at
5 years
it, say
experience.
normally you
No,
can
no,
look
what
at
I'm saying is, since the Lordship says in the earlier bench said 20, we can't make it 0. So that's the only way of working. What's a workable experience? Just put 5 years experience. When you say 5 years experience, when you say experience in the concerned specialty, he can do it only after he starts finishing his course.
After
Experience in the concerned specialty.
It should be after post-graduation.
5 years
No,
after.
but I'm submitting, one second. He can't do the concerned specialty unless he's finished his post-graduation. Let's look at it that way. When I say 5 years experience in cardiology, only after DM cardiology is taken 5 years.
What about MD medicine? Can a member?
According to us, that also should be taken into account. We can say 5 years after completing MBBS, it should be enough.
Or you can say of,
Because
or we
I
can say
mentioned there could be many
with
parts
at
of India you may
least
not
5
get
years
doctors.
of with at least 5 years experience
After
of the concerned specialty.
No, you can also say after,
Of
5 years
the-
experience after completing medical education.
No, we have to say of the concerned
Concerned specialty.
That has to be there.
No, I'm only submitting, when I say concerned specialty, it ipso facto means he has completed that MD course and has worked for 5 years. That is my humble, I'm putting it that way. Because he will not be a concerned specialist till he has passed the exam.
With at least 2 years expert, with at least 2 years experience of the concerned specialty is sufficient then.
More than.
All right. Then what is the next thing? Who in turn shall visit the patient in the presence of his guardian, close relative. late, close, relative, yes, relative, here also
Yeah,
guardian,
guardians related, yes.
guardians relatives.
Right, suppose
Here we may not.
in a lighter vein, the General Clause Act will apply to a judgment. Singular includes plural verbs.
And form an opinion within 24 hours, the case being referred to it,
Yes,
whether to certify so and so.
Lordship may make it 24 hours our request.
And proving that.
Actually, we have taken maximum 48 hours. That may include anything below even 8. Suppose you take. But that is to be seen later, my lord.
That's right. No, we want to say this.
That has to be seen later. That is to be seen later. Please, I'll see it later.
Once it is constituted,
I give you
visit within 24 hours. 24 hours they have to visit and at least 48 hours. All right. Then what is the next one?
Lordship is keeping maximum 48 hours, bro.
We have said that
Maximum 48 hours. Okay.
that's okay.
Within 48 hours.
No, maximum.
So up to 48 hours. Up to 48 hours.
So what have you written actually? The primary board may take up to 48 hours to form its opinion if subject experts are not available. What is that?
No, first within 24 hours, if subject experts are available.
No. This is completely different. Please read it.
Yes, the primary board may take up to a maximum of 48 hours to form its opinion if subject experts are not available. That is available within 24 hours.
So then can you have a primary board without that?
No.
It's a superfluous expression.
Eh?
Superfluous expression.
That's
the second part.
Then why did you agree for this?
No, sorry, they're not superfluous, please. It's a great application of mind. Suppose the hospital doesn't have doctors within 24 hours, then they have to get somebody from outside. Then those will be, if you can, subject are not available within the same hospital. If subject is not available within the same hospital. 48 hours, Lordship, I would say subject also matters fee.
No, you have given 48 hours, that's sufficient. Again, saying that, if they
No, 48 hours, if the experts are not available in the same
No,
hospital.
this is completely unacceptable.
No,
Yes.
kindly see.
No. What are you saying? You're saying primary board may take up to maximum 48 hours to form its
Yes.
opinion if subject experts are not
No,
available.
we are saying primary board will take within 24
Oxymoron.
hours. No.
What
Kindly
does it mean?
Until Lordship.
Ah.
Please see it again.
Ah.
Primary board will take up to 24 hours.
Correct.
Suppose that hospital doesn't have two extra subject experts in the concerned specialty. They
Correct.
must come from some outside hospital.
Correct.
That may take extra time.
Correct.
So that also must be done within another 24 hours. Because the primary board, suppose it's a large hospital like government hospital or a large private hospital, they will have hospitals. Suppose that private hospital has only 10 doctors who they have only one oncologist. They require two subject specialties. So they'll have to get somebody else.
What you're saying in other words is
Yes,
this 24 hours is in a case where subject experts are available in the hospital.
in the campus itself, like government hospital,
In the
provincial
campus.
hospital, yes.
So the second red line is that when they are not available
Within the same hospital.
within the same hospital.
Your Lordship
They
may have
take-
the same
take
hospital.
up- Take up to 48 hours to form its opinion and stuff. So what you're saying is that 24 hours is over. Then they get only 24 hours to organize another team of
Yes,
subject experts from some other hospital.
yes,
They'll be obliged to come and give it within the next 24 hours.
yes.
I mean, that is, carrying it,
Mr. Datar,
that is carrying it too.
after such a long deliberations going on, I just put a stress on myself to know that is the reason the legislature is not coming at the place for the reason.
No.
They said that it is such a job for us and whatever we do, day or tomorrow, so something is wrong.
Or what Lordship may say.
So what we suggest,
Ah.
make it less complicated.
That's right.
Need something
As
for,
minimal as it
need
is.
Then
something,
you can delete
need
it.
something for the person to have to take a call.
No, my point is,
As simplify you do, as simplify it work.
Lordship is right.
If you suggest,
This is very complicated.
only,
No, what I'm saying is, suppose the subject experts are not available in the same
So
hospital.
we don't want to fix a time limit of 48 hours, which is just 24 hours more. You look at the situation. Just
Then
because
Lordship may put like this, I'm just suggesting.
at the earliest.
No, may.
Complicate and expand.
At the earliest,
Can I suggest like this? Can I suggest like this?
we don't make it so,
Can I just suggest
by
like
the hour and all that.
Mr. Datar, only one minute, listen.
Yeah.
Page 7 we are referring to, 199.1.
198.4.4. Page 3.
Sure.
This one.
This one, 199.1.
This is the second red line.
The second red line.
No, no.
I read with your permission. Primary medical board may certify the course of action to be taken. Now we are reading. Within 48 hours of the case being referred to it and stop. Leave the rest.
That's right.
Done. Agreed.
Now simplify.
Simple.
And leave something to be done by the person to who has to take a charge. You can't put everywhere if and but. That fellow will just go around in the corners and find out what is my role. That's why with Natarajan I asked the people, please leave it. This court is doing this business, this court may continue. We don't want to step in.
We are, completely tinkering with it like a
Correct.
review, because this is not contemplated by this court.
And there's no
We have-
occasion or requirement to complicate all this.
No,
There's
no.
no as and when this.
But not
We shouldn't be doing it. We
We,
should.
we all try to simplify, but still complication goes on.
This is a patient person.
As more as you read,
Yeah.
more you will find something.
Brother, even this within 24 hours, this ultimatum for forming their opinion, I don't think, so they may need consultation, they may take, because ultimately everything hinges on it, on that opinion to begin
If I
with.
put 48 hours, 96 hours.
No, we are, I don't think. we should-
Within 40.
As long as God said within so and so time.
We should say at the earliest. Because there is no such thing in the main.
No, this 24 hours I agreed between all of us, Lord.
Just preferably within 48 hours. That's sufficient. We can, rest of things, they.
That is okay.
Preferably within 40
Preferably
hours.
within. Preferably within is okay, because that will send a signal.
That's right.
So this.
Where it's a completely
So
case, no chance, and they can take it within 1 hour also.
no, they're saying that the first render, that within 24 hours, we'll change it as,
Preferably within 40, just add preferably.
preferably within 48 hours.
Just add preferably there, Manoj.
That's okay.
That's right.
Who in turn shall, this is, so that other thing we are cutting out, The second thing, red we are going, that goes.
Alright.
Within,
Preferably.
preferably, yes, preferably. Within 48 hours.
No, they agree.
That is very fair. Not at all fair. 48 hours, 48 hours. Of the case being referred to it, whether this also, that's okay. The red other thing goes. Then this next is in the event of the when the medical board, primary medical board certifies that the instruction contains so and so ought to be carried out, shall forthwith constitute as secondary medical. So that is to be constituted by whom again?
Please see next page.
Hospital shall.
But I'm told is a panel of doctors under the Transplantation of Organs Act, where a person comes as brain dead or where organs can be harvested. So as it is incomplete, they will take a call. So those panel doctors, and this is agreed between the ministry and the doctor, the Institute of Indian Society of Doctors. But wants to see the copies of the act, we got the act.
They shall visit the hospital and if they concur with the initial decision also, so they may endorse the certificate to carry out. So physical inspection is necessary now. Shall provide his opinion within 48 hours. That is also again, we are going to make it within 48 hours.
Preferably within.
Preferably within 48 hours.
Preferably within, yes.
We can't put the knife to the neck. Preferably within 48 hours. Okay, so then the next sentence is this time may be extended to a maximum of 48 hours. That will go.
That will go, that will go.
That has to go.
Yes, yes,
Correct?
yes.
So the secondary board will be constituted by the hospital itself.
No.
Yeah.
There is
That's-
no.
That's what
I,
we agreed.
yes. That's what I wanted to point out. What has been agreed or what is of this one, it shall be by the district medical officer. That's what we pointed out. One doctor.
That is what this court has also
Yes,
said.
one doctor. And two subject experts who are not part of the primary board. That's all is the requirement.
Only one, what they said is in a large city like Bombay, I am staying, say, in Andheri. Where is the district medical or I don't even know. I've lived in Bombay for most of it. I don't even know where Chennai. I don't even know where my district medical officer is.
You had lived in a smaller cities, you would.
The doctor.
It's in Calcutta. Do you know where? We don't know where the
Doctor.
DMO is.
When we had to do our testing for.
Mr. Datar,
It's a doctor and chief medical officer from DGHS.
We have to undergo a physical.
So, Nataraj, who is to constitute this secondary medical board?
That's the only one doctor will be nominated by the DMO, district medical officer.
You know, when the primary report comes
Yes,
and it's favorable,
yes,
then the secondary medical board,
yes.
that will be constituted by whom? Somebody has to take the initiative.
The local hospital that can constitute one.
You have no difficulty.
No, there's no difficulty.
Then which part of it that is your against?
One doctor shall be nominated by the DMO for the secondary board.
One registered from the, that's what they have said.
Not the, as they suggested here.
So what should be done then?
It shall be one doctor shall be nominated by the chief medical officer.
what is that?
Okay.
Yes,
So that will be,
yes.
so board, they can constitute a secondary.
They can constitute the board.
But, so here we will say comprising of one board, so et cetera, et cetera, et cetera, et cetera, et cetera, et cetera. So before and at least two subject experts, we will add the words nominated by the chief medical officer. The problem will be solved.
Yes.
I think the same thing is there.
No, not seen. They said something about this one.
Here, you know,
Is on the page.
here we will say nominated by, see, this board comprising.
One I've got to interrupt.
You understood what you're saying?
No, yes, I want to, but it's not going to work out. What I'm told because there is a permanent panel under the Transplantation of Medical Organs Act. It's already there existing in the statute.
That's right.
Now, what they're saying is the person is dying. Primary board has taken a call. Now, as it is 24 hours plus 48 hours is there. Now, if you're going to start constituting a board, that doctor should be, they're saying when the panel is already available, why don't we use that panel is the suggestion by the doctors.
We have understood, but this is some kind of an agreed order. That is
Yes.
not a tinker with it.
Then Lordship,
It is, we are only adding this and nominated by the chief medical officer.
Correct.
We'll only say that it should be time limit. And there should be time.
the point is where, because.
They have to nominate,
No,
they have to nominate within a particular time.
But if I-
That we can add.
No, the DMO has to nominate, the DMO has to telephone the doctor, is he agreeable, not agreeable, all that, where is the?
I mean, can we completely tinker with the judgment?
No, I am saying,
Going.
no, I'm just saying, you say preferably by the DMO.
I don't agree with that.
Once again, I think he's, what he's dealing us and what he's correct.
And nominated by the chief medical officer, that's what I'm saying.
One registered medical, Pradhan, you have it? Page.
Yes,
Yeah,
yes.
One registered medical practitioner from a permanent
nominated by.
panel of registered medical practitioners empaneled by chief medical officer.
Of the district so and so may also designate registered medical practitioners empaneled under section 3 so and so, so and so. All those things are not required. We are only kindly put it in a simple words. One doctor nominated by the chief medical officer
Yes.
and two others.
Lordship will just do one thing, if I'm right, just correct me if I'm wrong. Just go to the first three red lines, not page 4. One registered medical practitioner from a permanent panel of registered medical practitioners.
All those
Panel by
things, we don't,
full stop.
those things we don't have to say.
No,
what
full
is
stop.
going, why are-
Lordship will just put full stop after the district and
And one registered medical practitioner nominated by the chief medical officer.
Officer.
Yes,
What, why complicate it?
yes, she wants to say
Et
something.
cetera, et cetera.
But she wants it because she discussed.
That is not, let's close it. I mean, don't keep it, like this. Very complicated.
Yeah.
It's just one thing, which is that we.
Just a moment.
Yes.
One registered medical practitioner nominated
He's saying that from a.
by the
No, Lordship may keep from a permanent panel. There is a panel existing.
chief medical officer
No, there is a permanent
And-
panel nominated by the CMO.
and at least two then it will read like this, and at least two subject experts of at least 5 years experience.
Who are not part of the primary board.
That also must be added.
Yes.
Who were not
Can you Lordship just tell us the sentence?
we'll read it out,
Yes, sorry.
part of the primary board. So it will read like this.
comprising one registered medical practitioner.
In the event of a medical, etc., certified so and so, then immediately constitute a second medical board comprising of one registered medical practitioner nominated by the chief medical officer of which hospital?
Of the district.
Otherwise, it will be not clear. Of the
Of the
district.
district.
Of the district. Nominated by the board and at least two subject experts
Yes.
with at least the same word we use as we have used
Of it, subject experts with at least 5 years experience
in the
concerned
concerned
specialty. Now,
Same thing will
now, only one thing, just Lordship, just to reconsider one small point, subject to Lordship.
just a moment. At least let us complete that. With at least 5 years experience. The experience of the concerned specialty. Yes, what is it that you want?
Yes, now, Lord,
Then they shall jointly visit admit the.
that's all, that's all okay.
May say that they are not part of the previous board.
That also I have said, who were not part of the primary board, were not part of the primary.
I have to just say one thing. Lord.
Yes,
Now,
Yeah.
I am told
yes.
that every district, under the Transplantation of Organs Act, the chief medical officer has already created a panel
We will not.
of doctors who are permanently available. So what we are saying is, the person who is nominating can be from that permanent panel. So every time they need not go and ask anybody, that panel doctor is there. That's why they said, am I right? From a permanent panel of registered medical practitioners who are already empaneled by the CMO. So there is existing today in law, the CMO has empaneled 4 or 5 doctors in a district who are under this act. So let them be there. So instead of him
What do you
searching
say?
for
What
a
do you
doctor.
No, that is not acceptable. We deliberated upon it.
All right.
It will lead to a lot of.
We have already-
Leave it there. Let us leave
What
it.
we
Yes,
have already
let's go
said that
on,
it
move on.
should be relatable to the
Correct.
terminal illness.
Yes, yes.
Terminal
No,
illness.
no, that's not the point. About the,
Here
about the
also-
CMO.
Here also same thing
Here
applies.
also the same person should be.
Yes.
No, the point
We
is.
have said this, now that's over. That clause is over. Let us not,
All right.
let us go to
Don't delay this.
198.4.6, what is that?
He'll appoint from the panel. That's all. Person of person, that's nothing much.
No. This
Consent of the
you're-
person
you're
or person
deleting,
nominated by-
You're deleting,
If collector is not involved,
so that is gone.
yes.
That is gone. Then,
Yes.
then the consent of the person or persons nominated by the executor should be obtained regarding refusal or withdrawal of medical. Okay. Why, what is this actually?
That we agreed, not the collector, let's not involve the
No,
collector.
what is this actually? What is this 198.4.6?
No, that requires the collector to form another board, third board.
198.4.6 we are
Exactly,
asking.
exactly. Please see the whole thing. The
Ah.
board constituted by the collector must beforehand ascertain the wishes of the executor. If he is in a position to communicate and is capable of understanding the consequence of withdrawal, in the event the executor is capable of taking. So last time we said that the collector, don't involve the collector, he has no time. If the collector is going to form a board and that board is going to again ascertain, as it is that man is in hospital.
Wishes of the executor.
Yes.
What is the original clause that we read? It
Correct.
says, the board constituted by the collector must beforehand ascertain the wishes of the
Who's the
executor.
executor? The man who signed the advance directive?
That's right.
Yes,
Just see what it
Yes.
says.
yes.
If he is in a position to communicate or is capable of understanding the consequence of withdrawal, that's why, how do you cut that out?
No,
Why
but,
do you cut it out?
but how does the collector constitute the board?
No, that portion we can cut out.
Yes.
Now, what you have done is you have cut out the lock, stock and barrel, you have thrown it out. Please see it. You see,
Yeah, please explain.
you have,
Lordships, actually, this is an, if I may respectfully say, this is an error in the earlier judgment.
We
Because
can't-
you cannot ascertain the wishes of the executor because he has already lost decision making.
we are telling you, if it is not possible, let it not be possible, let it remain as it is. How are you affected?
Then Lordship may say the review board, the secondary board, don't put collector.
Collector will go.
You put secondary board.
Even otherwise, it is not the collector who is to ascertain. Please see what is done. The board constituted by the collector must beforehand ascertain the wishes, not the collector.
No, I know that.
Then,
What happened was in the earlier judgment, after the primary board, the collector to form a secondary board. We said, don't do all that.
we will say the secondary board.
It can be secondary. board.
Secondary
Yeah,
board, that's all. We will instantly, we will simply say the secondary board. So constituted by the collector will go.
All right.
Must beforehand ascertain the wishes of the executor if he is in a position to communicate and is capable of understanding the consequences of withdrawal. In the event he is incapable of so-and-so, impairing so-and-so, then the consent of the,
All that can continue.
yeah, guardian, there you have brought in person or
No,
persons. Correct?
Yes,
There we can bring in person or person.
yes. And first, you know, Lordship
Not
is saying,
a wholesale
the secondary board must, the secondary board must ascertain the wishes if he is in a position to communicate.
That's right, rest everything will
Yeah,
remain.
all right.
Rest is not, it's harmless and it let it remain. Okay, then 198.4.7. Hospital where the patient is admitted shall convey the decision of the so-and-so and the consent of the person named in the before.
Only intimation.
Before giving a decision.
Now, jurisdiction, judicial magistrate, you just inform him. So this is going to be a big,
Because that will be just withdrawing it,
just inform him, that's all.
that's informing it, that's okay. No change.
No, but there's before giving effect to decision.
That's right. Before, what is the purpose of doing that? Just to tell him that it's going to be done. But
I have not said they agreed, but I think before giving effect to another 24 hours primary board, 48 hours secondary board, go to magistrate, he must be informed. And I don't know how it's going to work out, but we leave it.
yeah.
Don't put before giving effect to one.
Necessary.
Or leave it.
Okay, leave it. Then 198.5.1, my God. If permission is refused by, it would be open to the person named that or even treating person approach. That's, I think it is.
Yeah.
That's okay, I think.
Yeah.
That's right.
Yes, yes.
Then 198.5, all this no change. Then come 198.6.4, where the primary medical board takes a decision not to follow an advance guide.
This is not.
The person or the person named in the advance directive may request the hospital to refer to so that's also okay.
No, this is if the primary board doesn't agree, there's the end of it. There is no question of referring that to the secondary board. It's not sitting in appeal, secondary board. On edition, where they said that it cannot be done. Only the positive decision can be referred again for the purpose of confirmation.
No, not earlier Supreme
No,
Court
what
said-
is the earlier provision at this?
Yes, yes.
198.6.4.
Where the hospital medical board takes a decision not to follow the advance directive while treating the person, then it shall make an application to the medical board constituted by the collector for consideration.
That's secondary board.
On that one. That's all.
That's secondary board.
No, yes, now what it is said, where the primary medical board takes a decision not to follow the advance directive while treating the person or persons named in the directive may request the hospital to refer the case to the secondary medical board.
What's wrong with it?
Then again, it has to go to the secondary
Yes,
board.
that's right.
They're sitting in appeal.
Same
Same
thing.
thing here. It doesn't make any
It's the
difference.
collector's board, secondary board.
That's right.
Fine.
It means that this is a, before you take up 226,
Yes.
you go to the second kind of appellate board, which may take a decision. That is
Should have-
already
that's fine.
contemplated, I think.
Take it.
Contemplated, isn't it?
Very well.
So one board refuses, the other board can do. No change. Then 199.1.
What was to delete in the end stage?
Where is that?
That end stage, that first red line has to go.
That's right. In cases where the end stage, that will go. Undergoing treatment. Everything else is there, which is
No, we said we did not agree on.
Lordship was put preferably within 24 hours. In that last three lines, so within 24 hours, please add the word preferably.
next to friend. Inform the.
Then Lordship may say the time may be extended if the expert or don't put 48 hours.
Be appraised for a person. Then the primary medical board has certified.
Well, may I just mention one thing, Manoj?
Time may be extended up to 48 hours. That will have to go.
Manoj, can I just,
This is much
can I
more
just put one
serious.
point?
This is much more serious because, you know, he has not given an advance.
Exactly. So Lordship has to say from this 199, it will have a subheading where no advanced medical directive exists. Above para 199.
That's already there in the judgment. It doesn't, part of it. What we are concerned is not that.
Hmm.
The consent is there, and the consent is there, consent in writing. The one problem we are pointing out here is that
Yes.
who will have to give consent in writing, the family members or?
Family member. Patient is in a coma.
Yeah. Who out of the family
The
members?
family member.
You can't improve on that.
Yeah, we can't.
And this primary medical board in the manner indicated earlier,
Yes.
same way.
Yeah.
So that will be substituted.
Lordship may say in the manner indicated in para.
Indicated earlier is sufficient.
Para India earlier.
That's sufficient. Then let us read thereafter, the treating team shall discuss with the family patients if any. And shall the treating them. Now here, you have said that primary board constitute a medical board in the manner indicated earlier. Where is it mentioned that this medical board should go and do inspection and then record a finding that he is so and so?
Meaning?
Is it there?
I didn't follow.
It speaks about which in turn shall constitute a primary medical board in the manner indicated earlier.
Yes.
Thereafter, what is to be done? The treating team.
Shall discuss with the family physician.
No. Instead of the hospital medical board, you have made it treating team.
Yes.
Shall discuss
Yes.
with the family physician.
Yes. Lordship make it primary board.
Because it was earlier a hospital board, it will be primary board.
Or it put primary board.
That will be, because otherwise we are completely changing it, no?
Primary board.
Yes. So that will be family board. Primary board. The primary board treating shall discuss with if any and the next step is and record the minutes of discussion during the next step shall be apprised. The pros and cons of withdrawal so and if they give consent waiting, the private shall necessify the course of action to be taken within this again. This 24 hours is coming.
Preferably.
Preferably within 48 hours. You want this 48 hours for this also? Because this is a case where there is no advance directive. This is being done by the hospital.
After the case or can have given their consent.
May certify the course of action.
The Lordship said, but suppose they want to consult some more records, is there?
That's right. This is their decision shall be recorded as a preliminary. In the event primary medical certified the option of withdrawing. Should we say that after doing, after inspecting and all that is not there? We found that what is the procedure to be adopted by the medical board, that how they should go about it.
I'm sorry.
As to what should be done by the medical board, primary medical board, it's conspicuous by its absence.
They put no pros and cons of withdrawal, borrow the Supreme Court language.
That's right. We are saying, doesn't say that they should do an inspection of the study the
Yes, because when they say pro and con, they are already inspecting.
implied.
Implied.
In between pros and cons, you take somebody's life. Okay. In the event of primary medical board certificate, and in the event the medical certifies the option of its own, the hospital shall consider the secondary medical practice. One registered medical practice. But that also, same thing.
And again, it will be like what lordship, one registered, same thing. Lordship.
Medical, unredical practice, nominated by the CMO of the district. Correct?
Yes. Or your lordship may say secondary medical board constitutes the manner indicated earlier.
No, let it be like, anyway, we are putting it.
Okay.
That will be better actually.
Yes.
Constituted in the manner indicated earlier.
Yes.
Why create unnecessary second medical board? In manner indicated about it. Here and before. Secondary medical board shall visit the hospital for proceedings and after studying may concur with the opinion of the primary medical board. Is that intimation shall be given to the hospital insurance and so on. So the medical board shall provide his opinion. There also we'll have to say. What is it that you have to say? Secondary medical board shall provide its opinion preferably within 48 hours.
And lordship cut off that subject of maximum can be cut off.
All those things we are cutting.
Yes.
48 hours of the case being referred to it. Then the last one we hope. What about 199.4?
See, I don't think any difficulties there. I don't think they have any objection.
In such case, the patient's next of kin may request the hospital to refer the case. It's the same thing actually. May request. What do you say, Nataraj, about this last one? 199.4. That's all right?
That's right.
The same thing.
Everything is applicable to
Same.
this.
So then goes to Article 26.
In case of the opinion that you had something here in case where the primary board is the opinion that life treatment should be withheld or withdrawn. But the secondary board does not concur with the opinion.
I don't put this. This can become the digital.
Opinion of the medical board.
Lordship may just say whether
Yeah,
you
this
go to
is
High Court, that para 200.
It says that you go to High Court.
Go to High Court.
I say if it's in the national digital, why bother about the High Court again? So High Court has to keep a separate registry, keep a file, keep
No,
a
no, no.
server.
It speaks about the right to go to the High Court. I
Yes.
No. Having
190.
said this, we think it's appropriate to cover a vital aspect to the effect life support is
Here,
withdrawn.
it has
The
to-
same shall be intimated by the magistrate to the High Court. It shall be kept in a digital format by the registry of High Court, apart from keeping the hard copy. Which
Where
was
are you?
destroyed after
Where
expiry.
what are you reading? Where are
There are 200.
Oh, you are reading paragraph 1. That there is no change.
Just before that.
I thought if the Lordship.
190.
We are sorry, we are on 199.4.
Yes.
Yes.
That of course that we
No,
are
there is some change, 199.4.
Ah.
Earlier it was once the primary board refuses, then he had a right to go to court under 226. See the left side para.
Now we are saying go to secondary board before.
No,
going to High Court.
that is not. So virtually will be tinkering with everything. Now again, they want that to be referred to the secondary board.
Go to High Court straight. No?
Straight to High Court, it should.
No, but then we have adopted the same.
That is for, yes, because it was provided in the previous judgment,
No, in the advance.
as it is provided.
I have no problem. If you want to go to High Court straight away, go, my lord. I have no problem. They're just trying to save the High Court's time. We just wanted that the family also is assured that if the primary board has said so, the secondary board has said so, then you go to High Court. If Lordship doesn't want secondary board, I have no problem.
So we are here only, we will simply add where the primary board.
Hmm.
The only change that we will be making is that we will be adding the word primary board. Because you follow
Now, Lordship will see 190.4.
199.4.
Yes, my lord, first primary board says you shall
May
not
not
withdraw
take
the
a
support.
decision to withdraw so and so, or the collector nominated but may not concur with the opinion. That let it remain as it is.
Yes.
What happens-
Either the primary board does not agree,
Then what happens? The patient is kept.
go to 226.
Yes.
If the secondary board does not agree with the primary board,
No, if you're not going to, if either, your two steps are there. If your lordship is going to accept the suggested change, there is a primary board says no, you will not withdraw life
into the
support.
matter.
But the relative said there's no point.
Ah.
Right, but the doctor says I will not do it.
Correct.
Then you can go to 226 and the High Court can withdraw. What we are saying is, go to the secondary board. The secondary board suppose says.
They've
yes,
understood what you have said, but
You drop it.
why not? We don't want to do that. So this will only, we'll add the word primary
That's
board
right.
in one
The
line.
the entire red line can be cut off.
No, we are just adding the word primary. There may be cases where the primary board may not take a decision. So we are adding the word primary.
It's already there, my lord.
No, it's not there. See, it's where the board may not take a
The
decision.
primary medical board.
That is what you have added, no?
Yeah.
We are saying in the original clause, we are just adding the word primary board, medical board, you can say. You didn't, on the left-hand side,
No, so it will be only one addition in the left-hand column. I got it.
only primary medical board will be added. So this is subject to what, you know?
The lordship has removed collector and all that.
That's right, that's right. Or the review medical board. We can make it review medical, isn't it? Secondary
The
medical.
secondary board.
Reporting to the.
If a collector nominated medical board, it will be the secondary medical board.
That will be the only change.
Yes, two changes there. Primary board and secondary.
That's right. So now what does it say? If you want to dictate it.
The lordship will also have to cut off this independent committee consisting of High Court mayor. Let it be there. Let it be there.
Rule or something.
It's a High Court call.
You wanted the date time. He was agreeing, he's agreeing. Agree. So he doesn't want that 1 day's time. Brother says, we'll go with it.
Yes, yes.
So we'll close it right.
So whatever, I'm here tomorrow also. I can wait here also.
That's
No problem. If your lordship wants to, I think there's nothing more left because everything is this. Unless just.
That is
most
what
things
we want
go
The
again.
one, there should be parameter to 198.4.7.
Sorry,
198.4.7.
4.7.
Yes, that parameter provision should be given to no advance directive also.
For the,
Yes. Reporting to the magistrate, that should be incorporated for where there is no advance medical
It's
directive.
already there.
I don't think. It's not there, I don't think.
hospital where the patient is admitted.
Please see
The
page 8.
decision of the primary.
198.7 is there. No, please use page 8. The secondary board shall.
198.4.7,
Yes.
where it mandates that it shall be given
That's
to
there in 199.2. Please
One-
see page 8.
199 point.
2. Please see page 8.
One second.
In that event, intimation shall be given by the hospital to the JFMC. By the
Chairman of the collector, so and so medical board to GMFC and the family members of the board, by the chairman of the collector.
In that event, intimation shall be given by the hospital to the JFMC and the next of kin.
Ah.
Correct, I'm taking. Take note. Seeking clarification of the judgment which is in fact been reported in which is the 2000?
2018, 5 SCC, page 1.
Just a minute, brother.
What happened?
No, you have started.
This is an application filed by so and so. So whoever is the applicant seeking clarifications of the judgment,
Can I request something, Lord?
the clarification.
Yes, can I just request something, Lord? So you can say the judgment was delivered. It was then found by the medical community that directives are not working out,
That's-
therefore they succeed.
We'll say that.
All right.
We have to begin.
Okay,
We thought we should begin with some little bit of formalism.
yes.
Application by so and so of the judgment reported in so and so. What is the judgment?
2020, 2018, 5 SCC, page 1, common cause versus Union of India.
That's right. A constitution bench came to be constituted on the basis of a reference made to it by a bench of 3 learned judges. Please correct me if you can. In the backdrop of certain earlier decisions of this court. In particular, this court was engaged with the question as to whether the court should issue suitable directions, stroke norms, or set in place norms to provide for what is described as advance directives. This court also was concerned with the question as to whether, even in the absence of advance directives, when a person is faced with a medical condition with no hope of recovery, treatment should be life support, and he's continuing on life support systems,
Brother,
stroke medicines.
this part, just little.
Yeah, I'll come back. The should be the life support system should be withdrawn. The court went on to dwell on the right of a person to die with dignity. Thereafter, this court has proceeded to lay down the directives as follows. You will take it down from 198 points so and so till right up to 200. Correct? Just take it down as it is. The paragraph. The applicant is approached this court within a short period, as we are advised to think, of the issuance of the directions aforesaid. The reason for approaching this court all over again appears to be that in the actual working of the directions, insurmountable obstacles are being posed. For instance, it is pointed out that this court has provided in direction paragraph 198.so that in the case of an advance directive which is devised by a person, it should not only be attested by two, it must not only be in the presence of two attesting witnesses, preferably who are preferably independent witnesses, but also it should be countersigned by the Judicial first-class magistrate. It is pointed out that this clause has led to the very object of this court issuing directions being impaired, if not completely defeated. There are other aspects which have been highlighted in the application. Paragraph. The respondent, namely the Union of India, has filed a counter affidavit. We find from the contents of the counter affidavit that the stand of the Union of India was that it opposed the application. As we have noticed, this is an application seeking clarification. Ordinarily, be it an application lodged in this court, blessed as it is with powers under Article 142, you would have thought that the application should not receive further consideration. However, we noticed that there has been a subsequent development. The development is in the form of orders evidencing an attempt being made by the respondent also to evolve stroke agree to certain changes. Several rounds of discussion, it would appear, has taken place between the officers of the respondent union, which not unnaturally includes the medical experts, correct? Correct. Medical experts. According to the applicant, the difficulties which they have encountered have been spoken of and approved of by a large number of doctors. And it becomes absolutely necessary for this court to revisit the directions so that this court puts in place a mechanism which effectively carries out the object of this court laying down the principles in the paragraphs which we have already adverted. Paragraph. Having heard Sri Arvind Datar, Learned Senior Counsel, what about your name? Dr. Sonia.
R.R. Show.
Sure.
Representing Indian society.
Also, you can. Yeah, I just give you a name. This Arvind Datar, assisted by
Dr. Dhwani Mehta.
Yeah, that's right. But then what is her? She's been. We are talking. Okay, okay. Take that names also.
But are you also
Medical doctor, she's a legal PhD.
Okay. What is the name?
Dr. Dhwani Mehta.
That's you. That is assisted by, you can see all that.
We'll give the name.
And Sri Natraj, K. Natraj, Learned Additional Solicitor General, appearing on behalf of the Respondent Union. We are of the view that the directions contained in paragraph so and so, so and so to so and so, so and so requires to be modified, stroke, deleted as hereinafter indicated. Paragraph. So then you have to take paragraph 198.3.1 shall read as follows. Correct? We just tick and give it to you. All these things which are agreed.
But may I suggest the Lordship can put in it will be a reported judgment. So if it can be.
We are not very keen about that. We are not very keen about it being reported.
No, it should be, no. The whole country should know.
All right, let it be.
So then it's a table that you can understand them.
Yeah, so we have already put down the directions earlier,
No, Lordship put the direction earlier.
but you want that to be
I'm
table.
suggesting, Lordship may think about it.
Tabular.
We can put it as a table.
Table.
So we can, even if it is repeated, because it doesn't matter. But you just put this as it is, as it is, and with the changes which have been brought out here.
But can I suggest that I'll give a soft copy to the court? It'll be easy. So retyping everything.
That's right.
I'll give a soft
Whatever
copy.
is- whatever
So that
is-
it'll be easier for them to, instead of typing all over again.
No, because we have also brought about some changes.
Correct, correct. So in that soft copy, they can make all.
That's right. If that is so, let it be done that way.
Yes.
There's nothing more to be done.
That's all. I'll ask them to give a soft copy on a pen drive or something, or email it to them.
Provided it contains whatever is the changes that we have brought.
Yes, yes.
It will be- recorded. Whatever is indicated. Correct?
Probably one last thing.
Anything more you want?
No, only thing there, Mr. Shuri, I didn't.
No order has to cause.
No, this is Roy was mentioning about Arun Shuri. I was speaking to him over the weekend. So I said about this book preparation. He has personally signed the copies for each of them. I also get a copy to Mr. Mukherjee. Not a very good book to give as a gift, but
I want to give a reminder of that.
he has signed it personally for everyone.
You have to give direction to
Each of them.
Not signed.
No, Your Lordship, second page.
the second page.
It's an advice. Prepare for death.
Preparing to die. He said that's the most inevitable thing, but nobody plans for it.
So we must thank all of you because I think you're all acting pro bono.
Yes, yes.
So that is something which is hope for you. You have spent so much of your time,
No.
Nataraj, all of you.
It's always pleasure.
We think only
Ultimately,
when we go to
it's
the
for the
cremation
benefit of.
What means?
ground- when we go to the cremation ground, we think for it. Immediately coming out the cremation ground, everything is over.
My brother wants one thing to be added.
Yes.
Is that registry will communicate a copy of this order to all the high courts.
Yes.
So that, they are made aware.
Because the report may take some time. The law reports may take some time.
That's right. So
Because they have to formulate rule for storage.
Yes, yeah, you're absolutely right.
the registry will communicate a copy of this order to the registrar generals of all the high courts.
Can Your Lordship add a sentence? The High Courts may formulate the rules expeditiously so that they also complete.
What is that rules?
No, about storage,
Storage of these
that's para 200.
books.
Okay.
And my lord, doctor says also to the CMOs of the district.
It should go to the chief medical officers also.
Yes.
Go to the chief
Mr.
medical
Natarajan.
officer.
Medical office, yes, we'll,
It should go to the.
yes,
chief
we'll
medical-
also go to our
And perhaps
But how many CMOs are
Can I
there?
say one thing?
communication.
we'll get it up, we'll get
And
it.
then the High Court registry sent to the CMOs in that district, that will be easier, instead of we sending it to 600.
That's right.
No, not you,
That will be
but
better.
central government should
We'll
also,
also get
Yes.
it.
from their.
Yes, from our end, we'll get it.
Let it go to the
Because
I could tell
CMOs may
health
not come under
secretary.
the unit order.
Yes.
of each state.
At least the
High Court and
information
health
should,
secretary. No, my lord, just
Or you
suppose
can
to say
put
High
the-
Court and health secretary.
the health secretary.
That's right. So if it.
The health secretary,
This copy will be sent to the high court.
health secretary for
So we let
communication,
them do it. Let them
for
do it.
communication.
Health secretary
That's
for
not all
upward
right.
communication to the CMOs.
The registrar general of the high courts will dispatch a copy of this order to the health secretaries in the respective states. Union territory, you'll have a union territory also. So.
Lordship will say for onward communication to the
For
CMOs.
onward communication
To the respect all the CMOs in that.
all the CMOs in the state stroke union territory. Anything more?
That's
At a,
Indian Society of Clinical Care Medicine, with the appellant, I want to thank you, Your Lordship.
They're just doing our duty.
It was a long way patiently.
Yeah, let us see how it works. That's right, that's right.
brother Joseph. One thing. Justice Joseph at a particular moment said that when the patient is suffering end stage and there is difference of opinion, that gave rise to a certain scenario in my mind. Suppose the spouse is there and they have suffered each other such a lot. The spouse is saying, no, you must immediately act on.
Immediately packed on.
Brother will say, I'm the happiest man.
But in a lighter vein, it was said that Winston Churchill was told that his opponent
Yes.
was suffering for some illness. So he said, I hope it's not something minor.
And if I was.
Won the
to be, I
Nobel
would-
Prize for Literature.
But that's for history of the English speaking people, not for the war series.
That's right. That's right. Yeah, that's right.
He also, is it for peace as well?
No, I think he got to literature.
He got Nobel Prize in literature.
For literature.
But Lordship, he wrote those 5 volumes on the war, Gathering Storm, this, that. But I was told that he won the Nobel Prize for his book on the history of the English speaking peoples.
Have you ever
People
read?
with plural, yes.
Yes, people.
Yes, there's a collection of his speeches.
Yes, yes, yes.
Have you read just
Standing.
Churchill's
There's also
letter?
DVDs. Huh?
Churchill's letter for his son, written to his teacher.
No, I'm not read.
I think it's a thought which one.
Pinnacle, I mean,
Yes.
how very reaches.
Yes.
Even G.K. Chesterton's letters to his son.
Oh,
his letter for his son
Outstanding,
written for a teacher.
In fact, Justice
And
Nariman,
what he want his son to develop in
Yeah.
passage of time.
in fact, my lord, Justice Nariman,
Orthodoxy, his book, Orthodoxy.
who's Churchill.
Churchill.
DK Chesterton.
Yes, Orthodox.
Lovely.
But only one, since we're ending around the Justice Nariman, we did a service tax on clubs. So the clubs are mutual associations. Can you have service tax on clubs because they are providing the mutuality? So there's no question of service provider. and
That's
service.
right, that's right.
So Justice Nariman starts with the thing where Churchill was a member of the Bangalore club when he was
Yes,
in
yes.
India, and he has not paid his dues.
That's right.
He's in arrears.
Bangalore club.
He's a defaulter.
He's in arrears, he's a defaulter. You're
That really
I'm not a
says that-
defaulter of any of my.
you're a fan. All right, so we're back to, thank you.
Please, great.
I'm fond of God
Arbitration, yes.
and I'm a member of so many clubs, but I'm not a defaulter.
He wants to show Babur's letter to Humayun.
Different thing.
Whatever it is, you can say.
Sorry, no?
There's a letter on different subject. Babur's letter to Humayun.
Okay.
What you have to keep.
See.
Important.
It's there, but on net.
Somebody's life is in your hands. If you miss out on one word, you lose, you will be responsible mentally. Yes.
Dip your wisdom.
Yes.
But that's not on death.
No.
So how to run?
Yes.
Please follow.
Yes.
Essentially, what has been argued before my lords is that the only thing coming in the way of smooth arbitrations
So you were saying section
But
9,
I'm
8.
saying that what the main argument appears to be that what is coming in the way of smooth arbitrations is the Stamp Act. My lord, I am saying that Stamp Act deficiency, my lord, if the sections are not complied with, that is a minuscule portion of many, many vast agreements in the commercial world. Today, like Suraj plans, if this honorable court says that the matter cannot be referred to arbitration or a section 9 relief cannot be granted, there is no way, my lord, in which the sections and the stringent sections, I would say, of the Stamp Act are not complied with. And there is no reason for them to not be complied with. Because it is not just about, my lord, the state losing revenue, but it is also about the feeling that one can get away with it, can possibly get an interim relief under section 9, can also wait it out. My lord, section 9, subclause 2 has not been considered in these judgments.
Let us see that.
My lord, which says that within,
Give it. And give the whole set.
my lord, in the course of my arguments, I will again come to 9.2, but my lord may see it.
Yeah,
My lord is seeing that 9.1
yeah.
is a party made before or during arbitral proceedings. So, my lord, not just before, but also during arbitral proceedings, the section 9 relief can be granted, or any time after the making of the arbitral award.
Mm.
So, my lord,
Just one.
You take actually, so that, we.
my lord, then
Will-
because my lord, I have to show bottom landscapes in some detail, because that is the
But
judgment.
I just want to say one thing, my lord. If we are to go into, my lord, the reference was actually very narrow. My lord, if we are to go into section 9, that will expand the scope. I can understand my learned friend has serious reservations about some aspects of section 9. I may or may not share them, my lord. But this may not be the forum to go into, my lord, the 9 aspects. Subject to that, your lordships may go into it. Then I'll address your lordships on section 9. Because otherwise, my lord, then we keep, my lord, going into a large number.
Her apprehension appears to be.
That
that
will-
our ruling on. the-
May affect.
in
My lord,
fact,
your lordship
Stamp
may
Act
may
under 11
may make it
will
clear.
have direct impact on.
Right.
Nine.
I'm saying, my lord, your lordship may make it clear. According to me, it will have, I can show that 9 has a different regime and 9, my lord, may be treated separately. I may agree with some of what my learned friend says, but my lord, this may not be.
Not necessary to go into it.
Lord, I would say that I must make out a point on section 9, because, my lord, it will have some consequences. And the learned amicus may also point out to the court what these ramifications might be
Just
or
take
might
a-
not be.
That is,
Yes.
Ms. Tiwari, you see, we are sitting in a reference,
Absolutely.
right? Now, perhaps the amicus might have confined his argument, limited to what is referred. And suppose this section 9, it will definitely or may have an implication. One is not ruling that out. But such an argument has not come forth from the other side, or rather the amicus.
Rather the amicus, I would say, not the other side.
No, amicus, I should.
Amicus, my
Yeah,
lord.
yeah, correct.
My lord,
I have
if the
immediately
amicus-
taken back my
Yes.
word. There is no other side. There's only amicus we have heard so far.
Yes.
So
My
when
lord,
I say
the
amicus,
appellant has made a point of it.
no, correct. So the amicus has now made a submission. Then we have to open it. You can't be just, sort of.
Two things, my lord, I'll say to that. One, that I will show, my lord, from the judgment itself, that why indirectly the reference is also there to section 9. And I will also show to my lord that in global 11.6a was not being considered or was not argued and yet considered, my lord. It was section 8 point. And my lord, then there was a reference, there was an 11 also, but my lord, 11.6a specifically was not argued, it was considered. And my lord, when this reference is made, the paragraphs of Garware which are referred, my lord, and the paragraphs of Vidya Dolia which are referred, my lord, that has a direct implication on referring 9, my lord. Because, my lord, in para 37 of NN Global, 9 has completely been discussed and decided. That is the issue today, my lord.
Where is that portion?
Yes,
Let us
my lord.
decide. Let us see that.
Para 37.
Let us see that.
Let
straight
let
away.
me just clarify this, my lord. Neither in Garwan, my lord, 4 paragraphs are referred, my lord. 22, 29, 146, 147. Garware is only a section 11 case.
Because why we are asking you this question is, there is one reason. You see, section 9 permits a party even before the commencement of the arbitration
Yes,
proceedings
yes,
to seek what is described as urgent interim relief.
yes.
Correct. So if that, even at that stage, if the mandate of the Stamp Act is followed or not followed.
My lord, that's a live question, my lord.
No, what you're saying is, the impact is even more Because if you say that
Maybe.
stamp back should not be, it should be deferred to a later stage.
No, I am not
What will
saying,
happen is the interim relief will get.
no, Manoj, I want to
First
make
of all,
this.
it is to a court.
Manoj, yes, there are differences,
There are
Manoj. There are serious differences between an 11 and 6, 11 and an 8 situation where the court simply, Manoj, pushes the matter to the arbitrator, and a section 9 situation, which my learned friend is arguing, which may require the court to actually look at the document.
Section 8 is slightly similar to 11.
11, Manoj. So 8 and 11 is.
So you are actually pushing it there. You have to prove the existence of a valid agreement.
So, Manoj, that is one bucket.
Ah.
8 and 11 is
8
one
and 11
bucket.
go together.
Yes, that I understand. But Manoj, 9 is actually a little different because 9 requires some interim adjudication on the substance of the matter, on the merits. Manoj, prima facie, you have to look at the document. You have to give interim relief, not give interim relief. Whether at that point you will insist as a precursor to, my lord, stamp duty. For instance, my lord, I've
So
got
your short point is that in a section 9 proceeding, it will be fair.
It may be different, Manoj.
To insist that the stamp back is enforced.
My lord, in fact, there are judgments. I can, my lord, say in her favor.
We should not. That's not
It appears that during the pre-lunch section, you said
But what he said.
that the stamp act
9, what
have a
happens-
different application under section 11
But then she's.
and 8 and 9.
8 and
You cannot
9.
have a different application. That is what I think
9
that you made such an.
9 is a situation, my lord.
Please question that my lord had
Then
asked.
we open.
They cannot have.
9 is a situation. I'll give an example. No, I have some
What
model.
what the 3 judges bench says about 9.
My lord, 9, the 3 judges bench in one paragraph.
Let's see that paragraph.
Right.
That's it.
Your
Let us
Lordship
read
may see that
paragraph.
One, my learned friend at
Where is the judgment?
Para 37, my lord, NN Global
Para 13.
has, our compilation is page.
283. 283.
Yes, my lord. It's a different compilation that my lord.
Your comment.
I not may see it from my compilation, no, the reference judgment, the same
Which
paragraph
paragraph you want to read?
37, 37.
37.
In the case of an application under section 9 of the Arbitration Act, my lord has it,
Yeah,
1996.
just a moment,
Yes.
let my brother get. Page for 330.
My lord, in my
This new one, it is
330, it
426.
is 330.
first,
330 in my.
Yes, you got it. Yes, everybody's got.
The situation would be different if an application for urgent interim reliefs is filed under section 9 before the court and it is brought to the attention of the court that the substantive contract is not duly stamped, the court would grant ad interim relief to safeguard the subject matter of the arbitration. However, the substantive contract would then be impounded and the party concerned be directed to take the necessary steps for payment of the requisite stamp duty in accordance with the provisions of the relevant stamp act within a time-bound period. It is made clear that the payment of stamp duty on the substantive contract as assessed by the collector would, however, be subject to the right of revision appeal available under the relevant stamp act. My lord, this is where the problem is. And now if my lord may just see para 26 of the same judgment on page 327 of my compilation
Yeah.
to see, my lord, how it is in contradiction. 37 is in contradiction to para 26. In our view, there is no legal impediment to the enforceability of the arbitration agreement pending payment of stamp duty on the substantive contract. The adjudication of the rights and obligations. My lord, this is important for 9. Because in 9, the adjudication of the rights and obligations is happening on the substantive contract. The adjudication of the rights and obligations under the work order or the substantive commercial contract would, however, not proceed before complying with the mandatory provisions of the Stamp Act. My lord may see the contradiction between 26, where it says adjudication of the rights and obligations under the work order would, however, not proceed before complying with the mandatory provisions. And my lord may see para 37, where it says that section 9 relief can be granted.
What the court perhaps had in mind was that interim relief under section 9 is viewed differently from the actual adjudication by the arbitrator. That this is a matter which, because of the very nature of the jurisdiction to grant interim relief, it must be exercised immediately. Whereas adjudication of the main dispute, to resolve the dispute between the parties under the arbitration agreement, that should await actually the impounding payment of duty, etc. This is, I think, what we could make out from
No,
that.
that's what the honorable court was trying to say.
Correct.
But my lord, I will,
So-
I will show that the basis itself was wrong. Because the substantive contract has to be seen.
Go with it. Suppose sometime you want to register something. Okay, we want to try.
My lord, morning I can.
No, if you can conclude with half an hour, we can.
My lord, it'll be difficult because I will take some time to show at least 3-4 judgments, my lord. That's all that I'm showing, and the background, my lord, what my lord observed on why the court thought that it can be given the interim relief in this manner, my lord, the background to that, my lord, I wanted to show from the judgments. So just 2-3 judgments more.
One, I need about half an hour. My lord.
And then who else is there? There's nobody else.
Interveners will require around half an hour for the arguments and only address the questions which fell from my lords.
No, do you have anything new to add?
Yes, my lords. Only to address those questions which fell from
Like,
my lords.
briefly, just tell us in two minutes, what is your line of argument? So we'd like to know.
Our line of arguments would be, first of all, limiting to section 5 of the Arbitration Act, which is corresponding to the extension of the doctrine which my learned friend from the opposite side has argued.
Who is from the opposite side? Because they don't.
My lords, the respondent.
Standing on the other side.
Yes. And secondly, my lords, the other issue would be only limited to the later law and special act, the Arbitration Act being the complete code in itself.
Therefore, you're saying duty need not be paid. The court need not go into this.
Yes, my lords.
At the stage-
Interpreting the provisions of the Arbitration Act, stamp duty may not be paid in the section 11 stage or in the section 45 stage.
Need not be
paid.
No, stamp duty is required to be paid at the time of execution of the agreement, not at 11 or.
Need not go into.
We'll satisfy your lordships. Even on.
We want to know which side of the sort of line you are in.
Let's
The
go.
line as a-
This side. Not one.
Continue tomorrow because it's not. You don't want to see it's not going to no purpose.
Probably, your lordship, tomorrow, WhatsApp will come after, this Madhuri Diwan's marriage.
That's all we can do. Where is Madhuri Diwan?
No, her matter is next.
Then the Joseph Shine.
Your friend.
Where is she? We wanted to know whether, okay, she had said that she might report, that the matter doesn't require any adjudication. That's why we asked her.
We'll be ready.
That's right. Now, you're in the WhatsApp.
Yes.
So what is it?
WhatsApp's a new rule is on the unveil.
No, there's a bill already given. Section. There's the first bill, right? But there's the first bill, it was withdrawn.
That's right.
Then again, a new bill has come.
That's right. So it's going to be argued, or we thought that.
So because the other side had said that even if the bill is there, we want to argue. So I don't want to say anything. We place the matter, then lordship may decide whether you worship.
No, but issues in the bill, do they overlap with the arguments?
Yes, we have made a chart also.
You're appearing for WhatsApp.
I'm appearing for Meta. Mr. Sybil is appearing for WhatsApp. Meta is the parent company. It was earlier.
Facebook.
Facebook. Now it's called Meta.
It'll come tomorrow.
Mr. Banerjee, this para 37 and 26, I think.
Right.
What Ms. Tiwari has pointed out, although it is not specifically referred, it might have a bearing. You have to just reflect on that.
I'll reflect on that, but for that, then your lordships will have to go into the
So
section
that's
9.
why we are just looking at
There are 8 or
whether
10 judgments on section 9.
we are reaching a closure or not. We are just looking at.
Yes, my lord, that's
that
an
kind of a
important question because 9 is otherwise pending in matters here, my lord.
Oh,
Because it is pending.
Yes, my lord, it is pending in a couple of matters, I know. And in one matter, SLP was filed, notice was issued, it was settled. The full bench judgment. So, my lord, it is pending in two matters, at least in which I am.
So there in section 9, what's your argument that stamp duty will have to be
My lord, there the trend is a little different. There, what the courts are doing, my lord, is that as a condition of giving interim relief,
Oh.
they are attaching this as a condition, my lord. There are some Calcutta High Court, my lord, there's a parallel of 39(1) and 2. There the thinking is slightly different, my lord. Here the thinking is push it to the arbitrator. There the thinking seems to be slightly different, that you give immediate interim relief, because otherwise, my lord, if you are looking at stamp, then the matter goes. But in the meanwhile, somehow protect the revenue as a condition.
One cardinal difference is the absence of a clause like 6A.
6A is not there, my lord,
6A is
and,
not
my lord,
there in 9. So
and even 8, my lord, the words that it is only the validity, neither of those phrases are there in either, my lord, in 9, in 9.
9.
So, my lord, 9, I can address your lordships on 9, my lord. I have the 7 or 8
Let's see how
judges.
it turns out. After hearing her for some time, we'll get to know.
It's a little, my lord, that will expand the scope of, because the reference, as I read it, my lord, was only because there was a conflict between two judgments. This portion, my friend may not agree with, but there was no.
Garware, the other one is overruled, and then
Garware is 11. Garware is 11. My lord, SMS is 11. Vidya Drolia is 11/8.
Correct.
Here, my lord, there is some observation on 9, but my lord, that was really not, my lord, the conflict. It is one view which a 3-judge bench has taken. It may be right. It may be.
All right.
What is only one thing, Milad, on section 9 specifically,
Yeah.
there is an earlier view of your lordships. Because the whole thing boils down to one question. It's a temporary affliction. In the context of temporary afflictions, how have your lordships looked at it? There are your lordships' own judgments. So, Milad, I'm sorry I wasn't there, Milad, for the intervener. Tomorrow, Milad, all I will beseech your lordships is give me a little time. I'll take your lordships through the scheme of the act. Because what is necessary?
You're going to lie on which judgment?
So, Milad's first judgment is firm Ashok traders.
Please give us those.
I'll give that. This is 2004, 3 judges. What your lordships did in that case, if I can just.
It will help, so that if
I know, Milad, and I'm just describing, Milad.
You've already given a
Yes,
compilation.
that's the judgment I was talking about.
Which is the compilation? Let us see. Otherwise, you'll again take.
Milad,
This is a compilation.
My lord, this is filed.
2004, volume 3, SCC 155.
No, this is compilation of judgments 2. I mean, 1 and 2 means you have rounded up at 36 judgment. Right.
My lord, this is a volume of
Which volume
25.
is this 36th judgment? This is 36 judgment, is it? Naina Takkar, it begins, Annavur Purna.
This is your.
It's 26, Nena.
That's right, but you end with 36. You're going to refer to all these judgments?
No, not at all, my lord. This was initially what we had prepared.
So you tell us which are the judgments you're going to rely on, so that
Yes,
we get an
my lord,
idea.
my lord.
So,
Otherwise, if you come tomorrow, we'll.
No, my lord, we'll only point out, I said, my lord, that 4 judgments, which are the main judgments, and apart from that, 3.
Which are those
which
judgments?
are-
Please tell us.
Yes, my lord. My lord, Gotham Landscapes, Garware,
Just a moment.
Which- my
Garware, okay. Just take that down.
my lord, I'll just say it from the index itself. My lord has the index.
We don't have the index, that's a problem.
No, it is there. First page.
You're talking
Yeah,
about this.
yeah.
It's 3 and 4.
3 and 4. Item 3, item 4.
Gotham Landscapes, Garware Wallropes, Vidya Rolia, NN Global,
That is 4.
my lord,
Great.
3, 4, 5, 6. Then 8, my lord, Hindustan Steel versus Dilip Construction.
All right.
9, United India Insurance.
Hindustan
versus-
Steel is for what purpose?
My lord, Hindustan Steel also has been referred in these judgments, and therefore, my lord, I want to just show that why Hindustan Steels, my lord, could
All
not
right,
be
all
written
right.
the way.
8. Then
United India Insurance versus Hyundai Engineering.
we have reached now 3 plus 3, 6 judgments you have referred to.
Yes, my lord.
Yeah. Then
My lord, apart from that, the firm Ashok Traders at 23.
What point is that?
My lord, firm Ashok Traders say that a section 9 relief, my lord, will not arise from the contract itself. There's a one-line observation there, which my lord ultimately Gotham Landscapes uses to say that therefore for section 9 you will not look at the substantive contract at all.
this
That
Gautam
is the
Landscapes, is it overruled? No.
My lord,
My lord,
partly overruled by Garware. But the principles on which 11 has been based, exactly the same principles 9 has been.
No, my
based.
lord.
Decision.
With utmost respect, may I just say in one line, the question your lordships is considering is what happens if there is a temporary affliction. In firm Ashok Traders, what happened was there was a dispute under a partnership agreement. The partnership deed, when it was relied upon and a section 9 is filed, the effort made is no, you cannot grant relief because 69(2) comes in the way. It's an unregistered partnership. Now, what your lordships noticed in that judgment and why I am relying upon it as an intervener is to create an equivalence to show there also the registration is a temporary affliction. Let's say I were to register a partnership today and I haven't registered it. I may register it a month down the line and tomorrow morning there's a dispute and I am told no, you cannot seek relief. Now, what if I were to register it day after tomorrow and come back? The affliction goes away. What your lordship said in firm Ashok Traders is 69 will not stand in the way because what we are doing is we see that there is an underlying contract. It is a partnership deed, but we are not bothered about it. We are culling out the arbitration agreement from that to give relief. So that is, my lords, I want to show that tomorrow.
These are the judgments you wanted to rely on.
Please, man.
Correct. So,
Most of these I have cited, my lord, United, Hyundai, Dilip, all these have been cited, my lord, except for, my lord, I have made some guidelines, your lordships may have a look at it.
Hand over tomorrow.
I'll handle it. My lord,
Yes, give it. He wants to read it.
yes.
Grateful.